Facts on 99.3 Nigeria Info. I'm Sandra Ezekwesili, and you've just heard the 5 p.m. news update. That means it's time for the Big Hard Fact, where we dive deeply into one big issue in Nigeria today. And today we want to look at the Supreme Court's decision in the Imo State gubernatorial election petition. Now, as you all know, the Apex Court affirmed on appeal the petition of Hope Uzodinma of the APC and declared him the winner of the election in the place of Emeke Hedioha of the PDP, who had previously been sworn in. Now, we have Eric Nlemibe in Imo State. He'll be joining us on the show eventually to tell us what's happening there, because for as long as that announcement was made, that verdict was announced, Imo State hasn't exactly been peaceful. Now, today's big hard fact is that the Supreme Court of Nigeria declared Hope Uzodinma the winner of the Imo State gubernatorial election, replacing Emeke Hedioha, previously declared by INEC. That verdict sparked a lot of commentary and a lot of debate. There have been loud voices both agreeing and disagreeing with the verdict, and you've had even louder voices saying that those who are agreeing or those who are disagreeing do not know what they're talking about. Some have called it a sound decision. Others have called it a miscarriage of justice. But we don't deal in opinions and speculations. It's hard facts. So today, we're laying out the facts of the case and the verdict so that you can come to your own conclusions for yourself. I'm not alone. I have some of the best legal minds in the country on the show with me. First up is Monday Obani. Thank you so much, sir, for joining me on the show. Hello, Mr. Obani. Hello. Looks like we don't have the connection to him. But we also have another legal practitioner on the phone, Onoja Ilemona. Hello, sir. Thank you so much for joining us.
Thank you so much for having me.
All right, so we're going to ask that you please hold on. Let's try and get Mr. Obani back on the line. Is that okay?
Yeah, that's fine.
Hello? Mr. Obani, are you there? Hello? Okay, that's not working.
Hello.
Hello, Mr. Obani. Hi.
I'm trying to reach you guys.
Yes, oh, sorry about that. Okay. All right, now that we have both gentlemen on the line, let me start with a general question that a lot of my listeners have asked over and over. Why does it take, Mr. Obani, why does it take so many days for the Supreme Court to publish the full reasoning for its judgments after giving the judgment? After all, they knew the precise reasons why they gave their judgment, right? Wouldn't it leave less room for controversy and speculation if they just announced everything at once, Mr. Obani?
I'm on.
Hello?
I say I'm not their spokesperson. I mean the Supreme Court.
Yes, oh, of course.
I can only make a guess.
Yes, of course.
The number of cases that the Supreme Court of Nigeria is handling is so enormous, especially during election time when they have election petitions they're handling. I think you discovered that there was one particular day they read how many cases that came from the Court of Appeal to Supreme Court, concerning the state governors. So after, dealing with such number of cases, you would expect some delays in writing all the reasons, in advancing all the reasons at the same time.
Okay.
They may take some time to do it, and do a thorough job, which is actually what they have done now.
Okay.
Because in the Imo's case now, I think the reasons they gave for the judgment has been released to the public, members of the public, and all that. I'm only saying that maybe that they will just go ahead and pronounce the judgment, but give reasons later because of the number of cases. The Supreme they keep on. They have they overworked. They overwork. Almost every case in this country ends up in the Supreme Court. Presently, which even those ones that arose from the customary courts all over the country and the ones from Sharia courts, still have to end up at the Supreme Court of Nigeria. So we need to do something about reducing the burden that the Supreme Court is presently shouldering.
I wonder if Mr. Noja agrees. What are your thoughts on why the Supreme Court waits, Mr. Noja?
I do agree. The Supreme Court is simply, and this isn't just the Supreme Court, it is much of our judicial system.
Okay.
It's simply overworked. There's simply too many cases. They're understaffed, they're underpaid, they're under-equipped. Up until this day, judges at almost all strata of our court system write their notes by hand. They take dictation by hand from lawyers. I mean, and in 2020, when there's so many, there's so much equipment, there's so many tools that are available. You just wonder how the Nigerian nation as a whole isn't growing and developing as quickly and as speedily as the rest of the world. And they're taking that into this also makes a strong case, which many people, like I believe, that for judicial reform, as Mr. Obani has rightly said, practically every case in the court gets to the Supreme Court. It ought not to be so. Our Supreme Court ought to be reserved for weighty issues of constitutional law and other things, of that manner. As it is now, practically every case on the interpretation of our laws, land matters get to the Supreme Court, divorce proceedings can get to the Supreme Court, custodial battles for children can get to the Supreme Court, and so on and so forth. So naturally, the Supreme Court is bogged down with all sorts of issues that, to the minds of people like me, it really shouldn't be. Our laws permit it, but it really shouldn't be. So we should preserve our Supreme Court to be the bastion for serious and weighty issues of constitutional law and such and such.
Mr. Obani, another question that my callers often ask is, what is the procedure for selecting the justices who will sit on the panel for a specific case?
That is clearly discretionary powers that is given to the Chief Justice of the Federation to select the panel members.
I see.
That is clearly within his discretion and power. Just like also with the constitution of members of the panel for the Court of Appeal, that is actually also the discretion and power of the presiding justice. I mean, the one that is clearly in charge, the president of the Court of Appeal. So nobody knows the criteria or the criteria that is there for the but I'm sure he has the criteria set out, whether they are very versatile with electoral matters, well experienced, and also they want to choose somebody that may not be accused of likelihood of bias. You have to look at. I hope his wife or his husband is not a member.
And things like that. Okay. Now let's go to Imo State. Governor Uzodimma's case was that INEC wrongly failed to count the votes from 388 polling units, and that if those votes were included, his vote count would be higher than Emeka Ihedioha's. And the Supreme Court agreed. And that's why he's governor today. Mr. Bani, here's something I need you to explain to lay people. Uzodimma was initially fourth. There were two other candidates between him and Ihedioha. Did the Supreme Court also count their votes? And if not, why not, Mr. Bani?
Well, the look of
Mr. Bani, your line is breaking up.
Okay, are you hearing me loud and clear now?
Yes, this is better.
Okay, I'm saying that it's...
Hello? Oh, that's...
You hear me now?
Hello?
No, I'm here.
Yes, we can hear you, but it's breaking up. It's chipping.
I don't know. Go to MTN. Well, are you hearing me now?
Well, yes, let's go ahead.
Yeah, what I'm saying is that the Supreme Court said, and we verily believe them, that the result of 388 polling units were excluded by INEC. And those polling units are INEC-recognized polling units. Am I loud and clear?
Yes, you are.
Yes, and that when it was time for collation of the results from these aforesaid polling units, that INEC excluded them. And that was the pleading, and that was the relief that Oboh Uzodimma sought at the tribunal, that the court should include those results which he apparently scored but were excluded. And so the two courts below refused to acknowledge the fact that election took place in those polling units. But the Supreme Court did, accepted the results from those polling units, and found out that Oboh Uzodimma had more votes in all those polling units. There were votes of other political parties, but they were in minority.
Okay.
The votes of APC, according to what the Supreme Court made us to believe, were more, because almost 213 votes came out of those polling units, and they were in favor of Oboh Uzodimma. Okay. They, of course, added the other votes of the other political parties, but they were not sufficient enough to make any difference. Rather, it was the vote of Oboh Uzodimma that came up to 213, and then added to 96,000 already scored.
Okay.
Remember, that was already assigned to him by INEC when the results were declared, which made him to come fourth. By the time he added 96 to 213, that is how he now came up to 330-something votes. 300 and something votes. More than that of Emeka Ihedioha, which was 270-something thousand votes.
Okay. Because
300,000 plus cannot be more than 270-something. Am I right? That is how number 4 magically became number 1.
Magically, I like that you said that.
It was addition. Yeah, additional review.
All right, Mr. Onoja, what are your thoughts on that particular thing?
I'm in the first place, the question to ask is how? To be able to...
Mr. Bani just explained how.
No, I mean, how do you see what to add in the first place? Our laws are very clear. Who conducts elections, right? Who do you take information for relating to what the computation of votes should be? There has to be a procedure that follows. I mean, INEC conducts elections, results are declared. In the discrepancy, these are the authorities specified by law upon which you can from whom you can receive evidence that can now aid you in reaching a decision one way or the other. So the question is, how do you rely on this sole source of information to reach one decision? If you study if you conduct a close study of the result sheet that emanate from the 388 polling units, which were discountenanced by INEC, you would immediately realize the reason why they were discountenanced by INEC. The election results from these 388 polling units had entries in columns for only 2 political parties. Election results from all the other 3,000 plus polling units had election results entered in columns for 70 political parties, because 70 political parties contested the elections. Straight away, you know that something is wrong. If on one set of election results sheets you see PDP, APC, AA, and so on and so forth. All the 70 political parties that contested the elections have entry in their respective columns. And then in these 388 political units in particular, entries are made only for 2 political parties straight away. You know, we watch the declaration of results all the time, and we see that the returning officer takes his time to announce the results for each political party, because entries are made thereon for each political party.
Yes, but are we not always saying? But are we not always saying of those that it's not important to name them if their votes are too small?
It's important. If they contested, you need to know what their results are. You need to know. If they got 0 votes, you need to know.
Can I come in now?
Now.
Hold on, Mr. Bani. I'll come back to you.
The question is, if you have already that, now, one of Hope Uzodimma's contentions, and one of the contentions of the Supreme Court, which the Supreme Court relied on, was that votes were excluded from that area. But what INEC did was INEC issued a Form EC40, I think EC40G, if I'm not mistaken, but issued a Form EC40, saying that results in these 388 polling units were not reliable. They couldn't rely on the process that emanated from these 388 polling units. It is well within, and it has become established in our judicial, in our political jurisprudence. And that's where INEC is uncomfortable with the position of silence or with the conduct of elections in certain areas. And they're empowered to cancel the results from that area and declare, on the one hand, a rerun election or supplementary elections, or on the other hand, to completely exclude them. Hence, in our political, I am from Kogi State. It has happened in my state on more than one occasion. And so because of that, from practical experience, I know that.
Let me come to you, Mr. Bani.
Yes. I'm not aware of any incident reports from any polling officers, because those results that the Supreme Court added were results that were signed for by the polling officers of those various polling units. They were signed by INEC officers, and they never produced any of those presiding officers from INEC who came and gave evidence that election never took place. That was even the ground the Supreme Court had to accept those results, because if you are proving that those results were manipulated or there was issue of forgery, you will not only prove the issue of forgery, you have to prove also beyond reasonable doubt, because you are making allegations that borders on crime. Even though it's a civil matter, anytime you allege crime, you must not only prove it, but prove it beyond reasonable doubt. There was no proof whatsoever, apart from the general traverse, that those people were alleged to have been, Oboh was alleged to have manipulated the results, which is ordinary general traverse, the thing you say by way of reply. There's supposed to be a more proof to show. That's what the Supreme Court relied upon, and that is also the burden that is always, placed upon the petitioner. If the petitioner is saying that this other person did not win election with the required majority, or it is marred with irregularities, they are asking you to now prove beyond reasonable doubt before you can succeed in upstaging the declaration of INEC.
Speaking of proof, Mr. Bani.
But in this case, let me finish now. The proof now, the onus now shifted to INEC. He's alleging that results were excluded. And INEC is now saying that it's criminal allegation against Oboh. You have to now prove that those criminal allegations are beyond reasonable doubt. And that's what the Supreme Court said. There was not even any ordinary proof, let alone proof beyond reasonable doubt. And in the absence of INEC trying to unsettle those results that came from those polling units, they were bound to add them to the results already allotted to Oboh. And that's how he got all the results that he got that made him to be number one. So
can I quickly clarify?
Yes, INEC did not disprove that election never took place in those units. There was no offer of any resistance whatsoever by way of adequate proof. And it is there in the reason they have just try and read the judgment that I've just
Mr. Bani, Mr. Bani, I read the judgment, right?
Yes.
Hold on, Mr. Noja, hold on. Mr. Bani, I read the judgment, right?
Yes.
And Uzodinma and the APC called a witness from the police who presented as evidence polling unit result sheets from the cancelled units. That's from that's from EC 8A, INEX INEX form, right?
Now, witnesses, yes.
Yes. Now, INEX response had two responses. One, that the forms were not authentic, and two, that the witness did not have the standing to present those result sheets. Now, I want us to take those two responses one by one, as well as the court's treatment of them, right? First, did INEC submit any proof to back their claim that the forms were inauthentic, and did they need to? I need to clarify that.
Yes, they did not. If you are alleging that those results are so, are saying that the polling unit officer, the peoples,
Mr. Bani, your line is breaking up again.
Are you hearing me now? Are you hearing me now?
Yes, this is better.
I'm saying that if INEC is saying that those results
Hello, Mr. Bani.
Hello. I can't hear him.
Okay, Mr. Bani, your line is breaking up really badly. Should we call you back? Can you find a quieter place so that we can call you back?
At all?
We're hearing you now. Can you stay where
you
you
are?
Me
now?
Yes, this is better. Yes.
Okay, fine. They are saying that those results came from recognized polling unit. Is that agreed?
Those results came from
polling unit.
Yes.
I can't hear.
Oh, I take out results from polling unit by.
Oh, that's quite
okay. You have to call me back. Call me back then.
Okay.
Call me back.
All right. Please end the call so that we can call you back. All right. Sorry about that.
While we're waiting to call him back, let me quickly clarify.
Oh, okay. So we're going to call them both back and then see. So we have Mr. Bani back on the line, it seems, but we're not able to get Mr. Onoja back. So let's keep trying that, and then we'll see what we can do with that. You're listening to Hard Facts on 99.3 Nigeria Info. I've got some of the best legal minds in the country on the show with me, on the phone with me anyways. And they're talking about this judgment that Nigerians cannot stop talking about out of Imo State, the one that replaced Ihedioha with Uzodinma. Ihedioha of the PDP with Uzodinma of the APC. Monday Obani is on the show alongside Ilemona Onoja, and we will continue this conversation in a bit.
Hard Facts will be right back. Welcome back to Hard Facts.
Did you know?
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 Did you know? Did you know?
Did you know?
Udoma Udo Udoma Akwaibom, Minister for Budget and National Planning. Udoma Udo Udoma was elected senator for the Akwaibom South constituency at the start of the Nigerian Fourth Republic, running on the People's Democratic Party platform. He took office on May 29, 1999. Udoma was re-elected in April 2003, again running on the PDP platform. After taking a seat in the Senate in June 1999, he was appointed to committees on public accounts, judiciary, banking and currency, science and technology, privatization of drug and narcotics vice chairman. In February 2010, as chairman of the governing board of the Securities and Exchange Commission, Udoma was criticized for retaining the posts of chairman of USCN, director of Unilever, and vice chairman of the board of Linkage Assurance publicly traded companies. Udoma declared his interest in these companies before being appointed and, as required by law, excused himself from meetings where issues directly related to these companies were being discussed, but there remained concern that in his position he might exercise undue influence or become involved in a conflict of interest.
Are you hearing me, sir?
It has to be consistent.
Well, I'm here.
We have to, ahead of time, let people know what our plans are, because what investors want is consistency. They don't like chopping and changing. You must tell them what your plans are, you must listen to them, and you must make adjustments to accommodate investment.
Did you know?
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 Did you know? Did you know?
Did you know?
Gentlemen, thank you so much for your patience and for finally allowing us to connect back to you.
Yes.
Okay, I'm Sandra Ezekwesili. If you just joined us, welcome. Hard Facts, it is right here on 99.3 Nigeria Info. Before the network disconnected us, Mr. Bani, you were talking about the verdict that was given and the burden of proof that INEC had but did not fulfill.
That's correct.
Go ahead.
So I was saying that, look, if those units, are recognized by INEC, it will also take only the people that conducted an election to say there was no election. And that can only come from the POs, that is the presiding officers. And I don't think there is any proof, because if you read the judgment of the Supreme Court, there was no time INEC produced any evidence whatsoever to the contrary, that election never took place in all those polling units. It's a question of evidence. And the Supreme Court has always placed a heavy burden on whosoever is making any allegation in electoral matter. If you look at all the cases, has always followed that precedent, that anyone that is making an allegation, the onus is on him or her in order to produce sufficient evidence. If you are saying that those results were manipulated, if you are saying that those results were forged by Hope Uzodinma, The onus is on INEC to actually produce a very powerful evidence to really contradict that fact. And according to them, the evidence adduced by INEC was very weak to really prove beyond reasonable doubt that election never took place on those polling units. That is actually why the Supreme Court had to now accept the evidence of the police officer who came with the copy, with the counterpart copy, because when election is conducted in every polling unit, every security agent is given a copy. The polling agent is given a copy, and then INEC gives their copy. So you can go and get certified through copy from INEC. But if INEC refuses to certify the result, the polling agent can produce their own copy. The security agent can produce their own copy. And if it tallies, of course, the court is bound to believe it.
Okay.
Now, if the results were signed by PO, the presiding officers, it does not lie in the mouth of the collection officer to cancel results. It does not lie in the mouth of the returning officer to cancel. Results are conducted at the polling unit. It can only be announced or cancelled at the polling unit. It can only be cancelled later by the court and not by any other officer, not even the collection officer, not even the returning officer. It's only the PO that has the right to cancel results at the polling unit.
All right, Mr. Noja.
Okay. First of all, an indirect contradiction of what Mr. Bani just said. Indeed, INEC came to court and said elections did not hold or were cancelled at the polling unit level in the 388 polling units in question. In fact, an INEC official who was head of logistics was subpoenaed by the defense to come to court, to the tribunal and give evidence as to whether or not elections held in these 388 polling units. He's the head of logistics for INEC. He was the head of logistics for that election. And as part of his testimony, he brought a Form EC40G. The Form EC40G was tendered as Exhibit D2R1 to R27. A Form EC40G is only issued where elections have been cancelled at the polling unit or the elections did not hold. It is the polling unit officer who then issues a Form EC40G. 1. 2, when he brought that, it was admitted evidence. Hope Uzodimma and the APC did not lead any evidence to contradict this testimony. None at all. 1. 2, he also brought a list of polling unit officers and tendered that list in evidence at the tribunal to say these were the people who conducted elections at these places. So match this. This is the person who cancelled the results at this polling unit, for instance. So the onus then was now to come and say, no, this evidence that you've brought is not real. It isn't true. The APC didn't lead any testimony in that light. That is 1. 2, on the issue of the DCP who gave evidence as as the petitioner's witness 54. On that issue, DCP Rabiu Hussein brought the 388 polling unit results. Right? He couldn't be cross-examined on any one of those issues. Simply because he wasn't there when the results were made. He couldn't testify as to the manner of entries into which the results were, the manner of entries onto those forms. He had no knowledge whatsoever of the contents of those forms, of those result sheets. He did not see any of the he wasn't in any of the polling units the day the results were made. He did not interface with the policemen who were at the polling units on the day any of those results were made.
Yeah, but Ilamona,
let me finish. For that purpose, he couldn't be cross-examined as to the veracity thereof.
But he was not called as an eyewitness. He was called to present official documents that were officially submitted to the police by INEC staff.
Which is why we should hear what the court has said relating to eyewitnesses' testimony. The Supreme Court has said severally, as recently as Article Abaka verse Muhammadu Buhari, the only witnesses who can actually testify are witnesses who saw what happened at the polling units, and only them can give credible evidence of what they see. See also Hashidu versus Goje, Oke versus Mimiko, Andrew versus INEC, see Okechukwu versus INEC, see Alex Oti versus Ikpeazu as recently as November 2019. The Supreme Court said your testimony cannot be regarded as credible if you were not an eyewitness on the day in question. Now, the allegation is often that the response is often that because you brought copies, duplicate copies of the result to court, it's admissible in evidence and reliance must be placed on it. I would also read the position of the Supreme Court from another case. It says there is nothing in that judgment which suggests that whenever a copy of a public document is tendered in court, the maker need not be called to testify. That would be strange. However, if the intention is to just tender the document, of course it can be done without the maker, as was done in this bar. But if the intention is for the court to act on those documents, the makers must be called to speak to those documents and be cross-examined appropriately. It is then and only then that a court can attach probative value to it. See Andrew versus INEC, Ikpeazu versus Oti, Buhari versus INEC, Gabriel Udom Emmanuel versus Okon Umana Okon. Umana Okon Umana. My point being, because that witness was not the author of any one of those results, he could never have been an appropriate party to give testimony about it.
All right, Ubani.
He couldn't have been. And this isn't just me that is speaking; it's the Supreme Court. How do you cross-examine a witness who doesn't know what was in the document that he brought to court? The DCP, under cross-examination, said he didn't know the contents of the document. He couldn't tell you what party scored what. How do you cross-examine it? Just how?
Mr. Obani, let me let you answer that question.
Yeah, after the Supreme Court decision in Uzodema and Emeka Ihedioha, I wrote a piece which I think I forwarded to you. There's some positive development from the legal jurisprudence that arose from a case. I don't know whether I forwarded it to you or you. And there was.
Mr. Bani, your line is breaking up again. Hello, Mr. Bani. Hello. Oh, that's quite unfortunate. Oh, hello. I feel like this is my village people. Hello. Hello. Oh, that's quite unfortunate. Okay. Well, we're also going to try to get in touch with our reporter who is currently in Imo State. He is Eric Ninive. Eric is there to find out if there are still protests ongoing in that state. Eric Nlemibe will join us on the phone as well. We'll try and get back in touch with Mr. Obani. But before we do, I have to ask you, Mr. Noja, how come the Supreme Court, in its judgment, did not refer to tendering of the form EC40G by INEC's head of logistics?
This is part of what people like me claim lead to a perverse judgment. This is part of what, because we hear stories about the shifting of burden. No burden shifted. INEC had proven, and they had brought a witness to court. A witness came to court. A witness tendered evidence, uncontroverted evidence, that elections did not hold. That evidence that he tendered came in the manner prescribed by the Electoral Act and by our other substantive laws. For some reason, the Supreme Court completely disregarded it. No, it shouldn't be. That's part of the reason why we say that there's a perversion in the judgment. We haven't even begun to speak about the fact that upon adding the votes from these 388 polling units, we now have a situation where the total number of valid votes cast exceeds the total number of accredited voters. if anybody who follows political cases very well will realize that was the reason why Senator Dino Melaye's election was overturned, because the total number of valid votes cast exceeded the total number of accredited voters. That's why Dino Melaye's election was overturned.
Okay, we have Mr. Bani back on the line. So let me come back to talking with Mr. Bani. I was asking Mr. Lemon, right, that the police officer who was called wasn't called as an eyewitness. He was called to present official documents that were officially submitted by the police to the police by INEC itself. Doesn't this mean that any representative of the police as an institution can appear to submit those papers and attest to them, not necessarily eyewitness from the polling unit? I know that Mr. Onoja listed a lot of cases from the Supreme Court stating otherwise, but I wonder what you think, Mr. Bani.
Sometimes those cases are distinguishable, when you read them. We don't have that time now to go through all the cases he has listed and the ratio, because sometimes the ratio, have to be with regards to the facts of the case. When facts are different, of course, the different ratio applies. But even if they are not, my write-up, which I did as I was trying to explain after the decision in the Oboh case came up, was that there are some positive development in legal jurisprudence in electoral matter that have just arisen from this case. Because what we hear most times from the Supreme Court is this issue of eyewitness. And then you have to call all manner of polling officers or polling agents to come and prove your case, in electoral matters. And the burden is very onerous. And most time within a limited time. That maybe the court is trying to reduce this burden by now saying, look, if we have copies of documents that are given to security agents and they are subpoenaed, and they come to court to tender those documents, and those documents have not been discredited. They have not been discredited by INEC officers, especially the POs. There is nothing wrong in the court in admitting and assigning or ascribing what they call probative value. That it is very, very rare development in our electoral jurisprudence for court to begin to assign probative value, to ascribe probative value to documents that come from proper custody, like the police or from the polling agents, of the political parties. Because sometimes I participated in an electoral matter in which I did one apply for public certification of the abuse, they neglected. Even when the court order, they refused. So are we now going to rely on an umpire that is very, very biased most times, that want to frustrate a petitioner? You're relying only on the document of INEC. So if INEC refuses to certify, you don't have any document or result to tender. So the court now is giving us a clue, even with this recent decision, that if you have result sheet, also a counterpart from your polling agent or from the Nigerian security agents who also get copies of this results from the polling unit, that they can accept it, not only accepting it, but also ascribe probative value, which is actually what happened in this case. So my own takeaway from this is that maybe the court is now trying to, knowing fully well the responsibility that have always, been upon the neck and shoulder of petitioners who have all these very difficult most times to really prove, with all the so-called witnesses you have to call. You remember in Articles K, the same Supreme Court was saying you have to produce up to 250,000 polling unit agents in order to come and prove a case that happened all over the federation and all that. Of course, the impossibility of bringing a 250,000 witnesses to come within the limited time allowed by law. That maybe the court is now trying to lessen the burden. Let it be that it's a healthy development, and let it be something that will be continuous. That's my own take in all this. But whatever my brother is saying, by all those cases, I said we have to look at the facts of those cases and also look at the ratio and really look whether the facts are similar to this fact now that it has happened in the Ariel's case. If it's not similar, then those principles he has enumerated and enunciated may not apply stricto sensu to this particular case that is in hand.
Okay.
That is the point.
All right.
And as I said earlier, the Supreme Court, let's go and read the judgment again. They're saying that the INEC did not in any way succeed
in proving those allegations, let alone proving beyond reasonable doubt. That is what the Supreme Court said, meaning they did not in any way, look at those whatever, thing they have done, got below. And to them, that was not sufficient enough to have actually excluded the results of a particular candidate. And let me say this before, I stop. It is also very important for us to really think how 388 polling unit result was excluded by INEC. We're talking about electing a governor that will govern a state. And we are removing almost 250,000 of populace who's supposed to participate in the electoral process. Why did INEC even continue to announce somebody who is a winner without even asking for a rerun? A rerun would have been better for them rather than going to announce somebody who have not satisfied the requirements of the law in being announced the governor of a particular state. So INEC also must not be free from blame, because excluding such number of voters who are supposed to participate in the electoral process, to me, is an injustice that maybe the Supreme Court has seen and tried to redress. I'm not making any excuses for any person. I'm not defending any person, but I'm saying that we must try as much as possible to also look at INEC as a body. Whether INEC is really satisfying us in our electoral process or whether they are doing more harm than good.
Mr. Noja.
Okay, very quickly, I would respond by saying that we simply cannot have, and I say this most respectfully to Mr. Bani, we simply cannot have this state of affairs that he's just advocated for. Why? The way of establishing evidence in any court, any judicial proceeding, is that you give evidence, you are cross-examined to ascertain the veracity of that evidence. It is under cross-examination that usually the inconsistency in the evidence given shows up. It's strike law. It is a constitutional right that every evidence given has to be cross-examined. Now, if evidence is received from somebody who just comes and dumps it upon the court in that he cannot lead any evidence into the existence of that document. He doesn't know the entries that were made thereon. He doesn't know the circumstances in which those entries were made. He doesn't know anything about the document. He was just called to tender it into evidence. Then the petitioner is asked, the respondent, the defendant, is asked to go to war with one hand tied behind his back because he cannot interview you. He cannot cross-examine you. So what Mr. Obani is advocating for is that we should have a situation where only one side of the law, of the argument, is presented before the court. It simply cannot be. I ought to be able, if you come and make allegations against me in a court, I ought to be able to interview to the root of any evidence you make and you bring before the court. The root of any document is the author. Now, the authors of all these documents in these 388 polling units are polling unit officers with INEC. They could all have been called to give evidence into the result sheet that they allegedly signed. Why were they not called? Not one of them was called. Now, an INEC head of logistics was called. He gave evidence and said elections in these 388 polling units were either not held or they were cancelled. And see our form that proves our position. He was no inconsistency. He was not controverted. On cross-examination, nobody controverted his position. No counter evidence disproving his position was brought before the court. How then do you say that INEC, the body constitutionally authorized to conduct elections, should be ignored for the police that was a mere custodian of result sheet? It doesn't add up. It really doesn't add up. Now, with respect to this thing about dumping results or documents before a court, again, I'll read from the Supreme Court. It says, it is therefore not difficult to appreciate the court below when it held that the appellants merely dumped those documents on the court. The court is not permitted to go home and interrogate those documents privately in the inner recesses of its chamber. This will amount to stopping for evidence, thus descending into the arena of conflict. This is the Supreme Court. Now, if the Supreme Court has taken that position in one case, why did it not take that position in this case? In this case, The policeman brought the evidence to court. Cannot give any evidence about, brought the documents to court and tendered them in evidence as exhibit. He cannot give any testimony whatsoever relating to the contents thereof. How does the Supreme Court that said we cannot go and shop for evidence before now come to this case where they go to the inner recesses of their chambers, shop for evidence? Isn't that by their own words, isn't that descending into the arena? I'm not casting any aspersions onto the integrity of the Lord Justices of the Supreme Court. Not at all. And there must be an end to litigation.
But I have to ask you, Mr. Noja.
Their principles, as espoused by the Supreme Court, they abandoned those principles. And they didn't give us any reasons why they did.
Did INEC and PDP bring up to the court that the total number of votes cast in the 388 polling units exceeded the number of accredited voters? And what did the court say?
What I am even saying to you is that they didn't need to do so. I agree that maybe they should have, but they didn't need to do so. Do you know why? Let me explain to you.
Okay.
The evidence that brings that calculation in the first place ought not to be seen by the court. The court ought not to place any reliance on it to the point where we're now doing a calculation in the first place. Why? Because our laws and then our courts, all the way up to the Supreme Court, over several decades, have upheld a pattern provided by law of tendering evidence before a court. And if you don't follow that pattern, then the court will place no probative value on it. The court shouldn't have even gotten to the place where it was calculating. The court should have simply been in the place where these documents were dumped before us. No evidence was led with respect to these documents. Therefore, no cross-examination or analysis was possible on these documents, as a result of which it is not before us. It is not properly before us, and we can therefore not place any probative value on it. If the Supreme Court had followed its own principles and our principles of evidence and our principles of jurisprudence that have been developed over several years, we wouldn't have even had to get to the point where we are calculating the results in the first place.
Okay.
We wouldn't have had to get to.
All right. Mr. Bani, what say you?
Yes, my learned colleague has been talking about eye evidence. I mean, somebody who witnessed, the process, the electoral process, coming to give evidence and not dumping documents. The head of logistics that he alleged was called by INEC, of course, was not an eyewitness to the election that took place in all the various polling units. At best, he would be in the head office to allocate materials to all the polling units. So he wasn't at the polling unit where election took place. So that is one with regards to that. And the second issue that I want to point out is that the relief that was sought by Oboh Zodema is unique in every respect. He was not saying that issue that there is no compliance with the Electoral Act, which is usually what most petitioners allege, or that the person that has been declared winner did not in any way pull the lawful vote, that will make him to be declared a winner. His own election took place in certain polling units, and those polling units results were not in any way taken into account. They were excluded. And that the person that excluded had no right whatsoever to do so, and that is the collection officer that is supposed to be at the polling unit. And in the absence of INEC trying to destroy that evidence that election never took place in those places that he alleged, the court was, according to the Supreme Court, was bound to accept those results, that no damage was done to his allegation that those results were excluded. And as long as no damage whatsoever was done by any credible evidence from either INEC or PDP, they were bound to be accepted by the court, and the court did accept it and added, and that made Oboh Zodema to be declared winner. I don't know, from my own, take, the cases he's been citing, the facts are different from this particular relief. The relief that is being sought is issue of exclusion and not issue of non-compliance with the Electoral Act, or that the respondent did not poll what we call a lawful vote, for them to be declared a winner. So if you have this kind of relief that is a bit unique in all respects, maybe also the proof is the INEC has the opportunity of reporting. And since they failed to report that election never took place in all those polling units, the Supreme Court had to now, accept those results as given by the 28 polling unit agents that tendered and that of the police, and that to them satisfied the requirement they needed in order to declare a winner. So to me, there has been, let's take into account the facts of the case. Let's also take into account the principle that the Supreme Court has established in this regard, that in manner of exclusion, when you allege exclusion, that the evidence you adduce and the manner of adducing of that evidence may be different from what my learned colleague has been citing with regards to when it is a petition alleging non-compliance or that you did not comply, did not pull the necessary lawful vote to be declared the winner of an electoral context. So that is, to me, what I have found out as my takeaway in this new principle that the Supreme Court has established within Oboh Uzodimma and Emeka Enyedoha's case. That is my take. That's my takeaway. And I'm going to write more articles concerning this particular case, reminding the Supreme Court that they should not depart tomorrow. We have found out that most times there is so much inconsistencies in electoral matters, and I don't know why, that they should remain and maintain their principle in all of these.
All right, Mr. Bani. Mr. Bani, we're out of time. All right, Mr. Noja, let's hear your final thoughts. Go ahead.
On page 30 of the petition, of Oboh Uzodimma's petition, on page 30, he says, the petitioners aver that the returning officer did not call for polls to be taken in the excluded or wrongly cancelled units before he returned the first respondent as the winner of the election. The third respondent ought to conduct supplementary elections, whereas in this case, the number of registered voters in the unit where the results were not reckoned with or were purportedly cancelled was substantially higher than the difference between the scores of the first respondent and the first petitioner. So even the petitioner himself was calling for for supplementary elections. He wasn't asking at the tribunal to be declared winner of the election. How then did we get to a point where he was declared winner of the election, knowing that it is strike law that no court should give what was not asked for by the petitioner? How then did we get to that point?
All right, let's end on that question. Gentlemen, thank you so much for your time. I wish we had 2 hours to continue this conversation. Unfortunately, we do not. So, Monte Obani, thank you for your time. Ilamona Onoja, thank you for your time as well. All right, that's where we wrap up Hard Facts today. I know, the time is never enough. We tried, by the way, to get in touch with Eric, our correspondent who is currently in Imo State, because we wanted to find out from him, how are things there? Are things looking up? Are things better? Are things still wild? But unfortunately, Eric Nlemibe wasn't taking his call. We'll find out about tomorrow, I'm sure. Thank you for being a part of Hard Facts today. We started the show by bringing you one big story. The 18th anniversary of the Armory blast at Ikeja Cantonment happened 27th January 2002, 18 years ago. On Checkpoint, we talked about yet another disaster happened at Egba. And right now, I'm handing you over to the news at 6, and afterwards, conversations with Rufai Useni. I'm online as Sandra Ezekwesili. Lagos until tomorrow at 3:15. Those were your hard facts. Good night.
More talk, news, and sports after this.